first matter to come before the court this morning is State of Ohio versus Shaquille Anderson. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If the appellant wishes to reserve any time, if you can let me know when you get started. I'm keeping track of the clock, as you also will be able to keep track of it yourself on the wall. When you are presenting oral argument, please do not use the names of any victims or victims of crime or minors, as we are recording today's oral argument and we post it on YouTube, the court's YouTube channel, after argument today. We have read the briefs and we are ready to see who you are.
Good morning, Your Honors. May it please the court. My name is Elise Frick-Gowander. I represent the appellant, Shaquille Anderson. With the court's permission, I would like to reserve 5 minutes for rebuttal. Your Honors, this case involves 2 interrogations. Both were coerced. Both were involuntary. The initial interrogation was also in violation of Miranda. Today, I want to focus on just one issue, and that is the voluntariness of Mr. Anderson's statements during that initial interrogation in February 2017. If this court does decide that that initial statement was involuntary, that means that Mr. Anderson's subsequent statements in March of 2017 are also inadmissible under the fruit of the poisonous tree doctrine. When this court listens to the audio recordings of these interrogations, you will hear that Mr. Anderson's statements were coerced through promises of leniency. Mr. Anderson was promised over 12 times by these detectives that he was not going to be charged with a crime. And when I say promise, I don't mean statements that he should tell the truth or that they want to help him. And I'm not talking about promises that are, specific to a single incident. These are explicit, blanket promises of immunity. Promises like at 9 minutes, 30 seconds. He might be taking notes, but we're not looking to charge him. We're not adding no charges, we're trying to close cases. They told him, well, you're not going to be charged. They told him, you're not going to be charged, you can't be charged. We're not here to throw additional time on you. And about 2 hours into the interrogation, Detective Stewart offered to give Anderson a written statement that she was not going to charge him with a crime. She said, I can promise you, give me something, I'll write on it, that I would not charge you with this. A few minutes later, she says, I promise, and you can keep it. We can pull a deputy or someone up in here. I'm not trying to charge you with this. It's well-established law, Your Honors, that promises of immunity can coerce a statement. In 2019, in Wilson, this court stated, evidence induced by a promise of immunity is coerced evidence and cannot be used against the accused. And that case is a kind of useful, it's a kind of remarkable comparison to this case because in that case the defendant was charged with sexual activity with his niece who was intellectually disabled. And this court decided that that statement was involuntary, even though the interrogation lasted less than an hour, even though the defendant was told multiple times in Wilson that he was free to leave, including at the outset of the interrogation. And even though the promises in Wilson weren't explicit like they were in this case, they were implied promises, suggestions that he wouldn't or couldn't be charged if he made a confession along the lines that the detectives were suggesting, that it was a consensual sexual activity. So compare that to this case, where Mr. Anderson was interrogated for almost 4 hours, where he was never told that he was free to leave or return to his cell, or that he was free to end the interrogation whenever he wanted, and where he was explicitly told that he was not going to be charged with a crime, was not going to get any additional time. Now, at a certain point in the interrogation, about 2.5 hours in, it did become clear that the detectives were going to charge him. They weren't only going to charge him with robbery, they were also going to charge him with murder. And so at that point, the detectives pivoted. And they pivoted to 3 very specific promises of leniency. They told him that if he confessed, he would be charged with murder 2, not murder 1. They explained the difference in their minds. They told him that murder 2 would get him 18 years, a specific time, 18 years in prison. And they told him that those 18 years would lie on top of his current time. And this is a few minutes after the detective has explained murder 2 and murder 1. She says, your time ain't gonna start after your robberies. You can lay it on top of each other. You're already doing this time, so it would lay on top of that. And she cites a specific case. She says, like the Weehawken case that I just now had, where the girl shot her boyfriend, she got the 18 years. She tells him she got the 18 years. Whatever happens, it can lay on top of what you're already serving. It's not going to start after. That's about 2 hours and 43 minutes in. So in addition to being promises of leniency, these promises are also inaccurate legal advice. It is not necessarily true that Anderson would be charged with murder 2, or that he would only get 18 years. It's not necessarily true that he would not get any additional time. In fact, some of these specifications actually have mandatory time, mandatory consecutive time. So given the charges that he received, it's legally impossible that this time would lie on top of his current time, that it would be concurrent. At the same time they pivot to these promises of immunity, the detectives also pivot to threats, or of leniency, excuse me. The detectives pivot to threats. And they threaten him with several specific harsher punishments if he doesn't cooperate. They tell him that if he doesn't confess, they're going to go for life without parole. Detective Stewart says, you can wait 5 years, you can do some craziness, and then we'll ask for life without parole. Then you won't get out. Then you won't get out, she tells him. They threaten to charge him with additional crimes. The robberies that they just finished promising him he wasn't going to be charged with, she says, we're not charging you on those. Murder is all I care about. Now, we could be assholes and throw them all up in here, because they all three go together. So these threats and promises of leniency are two sides of the same coin. On the one hand, they tell Mr. Anderson, cooperate and confess, you won't get any additional time. On the other hand, they tell him, if you don't cooperate, if you don't confess, you will never get out of prison. That's what they told him. And these threats and promises of leniency would make a statement inadmissible, even if it was a Mirandized statement. But the fact that this was not a Mirandized statement, the fact that he was never read his rights in this case, contributes to the totality of circumstances that make this an involuntary confession. And there were other factors in that totality of circumstances as well. He was never told that he was free to leave. This was almost a 4-hour interrogation. And he was in the coercive environments of a prison, as I explained in the brief, where he in fact was not free to leave the interrogation. He was not free to walk out of that room alone. We don't have to guess, in addition, what would have happened if Mr. Anderson had been read his Miranda rights. Because that happened later that same day. The detectives returned to the prison. They read him his Miranda rights, and they attempted to get the same confession again. Having been read his rights, Mr. Anderson asserted them.
And that was just an hour after the initial interview, right?
Just about. I'm not sure if it was exactly an hour, but yeah, same afternoon.
And he said at that point, I'm just too tired to talk anymore.
He did not say that, Your Honor.
Okay.
No, I think that was the gloss of the detectives at the hearing. He didn't say much during that middle interrogation. He asked 4 times, can I have a lawyer? And then he eventually, in the end, he just repeated, I don't want to talk about it, until the detectives left. He never said, I'm too tired.
And then he requested for the detectives to come back to the prison.
No, Your Honors. One of the detectives, not the other, one of the 2 detectives testified that his girlfriend had called them to tell them that he had questions. They don't mention that in the interrogation. And in fact, for most of that first 10 minutes of that second interrogation in March, most of that first 10 minutes, he is silent. The detectives ask him not to hear them out before he says anything. They read him his Miranda rights, and eventually, after about 9.5 minutes, they tell him that if he doesn't cooperate during that second interrogation, that they will charge him with the death penalty. He could face the death penalty. It's right after that he starts talking in March.
Counsel, when they went back on the first day and Mirandized him, and he asked if he could have a lawyer, and what was the response?
They told him, he asked it several times. The first time they told him no because it's closing time. And I believe all of the other times they told him yes, but did not elaborate. Yes, you can have a lawyer at any time. But then they continued to ask him questions.
Thank you.
We are just now into your 5 minutes or so. We may continue in reservations.
Thank you.
Good morning, and may it please the court. I'm Jacqueline Corder on behalf of the state of Ohio, the appellant in this case. And responding for just to begin with, just making a few points based on counsel's argument. I did want to talk about what are listed as explicit threats, and I would like to remind the court of the OC case, where the court decided that threats or promises that the police may make to take legal action against a defendant are not necessarily inherently coercive. And it is that inherently coercive police tactic that this court has to consider first when deciding whether a statement, whether it's the February statement or the March statement by Mr. Anderson, was coerced, which, by the way, is a separate analysis from the Miranda analysis, which looks for the confluence of custody and interrogation. So the first point of analysis is whether there was an inherently coercive police tactic, and that, again, is from OC and also from the Connolly case from the Supreme Court of the United States. So this court would be looking for things like physical abuse, threats or false promises, deprivation of food, sleep, or medical care, something that would be of such a character that it would cause an ordinary person to lose their will to resist. Now, discussing the advantages of telling the truth is not generally inherently coercive. Psychological pressure is not necessarily inherently coercive. And again, making threats or promises to take legal action against a defendant is not necessarily coercive. It is only if this court were to find an inherently coercive tactic that was used that it would then move on to look at the totality of the circumstances. And I did want to talk about the Wilson case that this court decided a couple of years ago. That case was one of my cases, and I remember it very clearly. That case involved deliberate lies by the officer who was interrogating Mr. Wilson. And that officer deliberately told Mr. Wilson that the acts that they were investigating were not criminal in nature, when they clearly were. That officer lied to that person and badgered him for that hour and a half that he was with her, and she literally told him, if you confirm the statements by the victim, then I'll let you, then this will all be over. Meaning, no future investigation, no involvement by the Bureau of Criminal Identification, no need to look into it at all. And that is what this court found to be inherently coercive. So this case is not like the Wilson case. And the court can look through the record and listen to both tapes of the interviews involved. And so the state submits that neither one of these statements, not the February one, not the March one, were coerced. Meanwhile, I also did want to talk about why the February statement was not custodial. Again, this court has to look at the totality of the circumstances and determine whether a reasonable person in Mr. Anderson's position would have understood the situation of that he was actually in custody. And that is the crux of the arguments today, is that, just to recap, Mr. Anderson is saying that the February statement was custodial without Miranda and coerced, and that the March statement was coerced and was the fruit of the poisonous tree. And I do want to talk about the fruit of the poisonous tree a little later, but again, the state's position is that neither one of these statements was coerced. The February one was not custodial, and the March one could not also be the fruit of the poisonous tree.
Council will obviously have a chance to go through all the record and listen to recordings and so forth before we render our opinion, and we'll do so. But do you agree that 12 different times that the detectives did indicate that he was not going to be charged?
I don't see that. First of all, there was no word immunity used. In addition, the officers promised not to charge him with additional robberies. And at several points among those 12 different promises, that's explicitly what they were telling him. So we're not going to charge you with any more robberies. And that was when you look at all of those instances taken in context, that's what they were talking about. So
But there also was supposedly the promise that there would not be additional time for anything.
no additional time for any additional robberies that he was confessing to regarding when they got around to saying, well, there will be a murder charge. The additional time would be consecutive time. And they were saying that he would receive that concurrently to the sentence that he is already serving.
That's what I'm getting at. So they were saying concurrent time, so he wouldn't spend any more time in prison, but he actually got consecutive time.
Yes, and unfortunately that was a mistake of law, but not a deliberate one. So that I don't see that they were falling into the same category as Wilson, where they're deliberately lying to him about the import of what he was talking about, or the import of what would happen to him.
Did they testify in regard to that? As
Yes.
to why they said that?
I'm not sure that I recall that they testified as to why they said it. They did talk about their statements, but I'm not sure that they discussed a motive for making that statement.
I guess I was just wondering, and again, we'll review it all, but I was just wondering if they had indicated in their testimony anything to the effect that that's their understanding of what the law was, or that they had researched it, or they just didn't know and they just threw things out, or what did they say? No.
Well, I don't recall them saying that they had done any research on it, but at least it was not like in the Wilson case where the officer said, yes, I used a deliberately deceptive tactic with him. That was not the case. So that's where I'm also drawing the line between Wilson and this case. And that Wilson, it was deliberately done. It was not mistakenly done, and it was not done out of ignorance. It was that officer deliberately lied to Mr. Wilson. So that was where that became, for this court, an inherently coercive tactic. Just briefly then, because I see I have less than 7 minutes left, I did want to discuss the fruit of the poisonous tree doctrine in case this court were to find that, which the state would not concede to, If this court were to find that the February statement were coerced, neither Ohio nor the United States Supreme Court have applied the fruit of the poisonous tree doctrine to statements alone. They have applied it to physical evidence that has been seized as the result of statements, not to subsequent statements. And that's from Elstad and the Tucker cases out of the U.S. Supreme Court and Ferris here in Ohio. And Ferris dealt with physical evidence that had to also be the sole basis for the conviction, and where the suppression would serve the purposes of the exclusionary rule, meaning to deter improper police conduct in the future, or also to serve the Fifth Amendment goal of assuring trustworthy statements. And we don't have that here. We don't have physical evidence. We only have statements. And this was, again, not a midstream case, or Mirandizing cases in cyber where there was a pause of an hour or two. This was a case where we had a month between the February and March statements. And briefly, I did want to also talk about the new federalism argument that Mr. Anderson has made. They're trying to carve out new or create new bright line rules for the state of Ohio based on the Ohio Constitution. Those arguments were not made at the trial court. They're therefore forfeited. And plus, they're novel arguments for the state of Ohio, so they can't be recognized on plain error. So we really cannot create bright line rules saying, first of all, that any person who's in prison is always in custody for Miranda purposes, or to say that the fruit of the poisonous tree doctrine is going to apply to non-physical evidence such as subsequent statements. So, and Judge Sutton, I did want, in my final few minutes, you had asked whether Mr. Anderson had asked for an attorney during that second portion of the February interview. He had indeed, and he was told that he could have a lawyer. Yes, that it was probably too late at that point in the day to have one out to the prison immediately, but he was never told he could not have an attorney. And eventually the interview ended because the officers realized he's invoking his right to counsel.
And what do you, I'm sorry, did you want to follow up?
I just wanted to ask a different question, actually. Were any promises of no additional time made in that second interview?
No, I don't believe they were.
I was going to actually follow up on Judge Sutton's original question, and you answered and said eventually. So they did continue to question him even after the city wanted an attorney.
They asked him some questions. Most, I'd have to go back through and take a quick look at the record, but my impression of that was, can we talk? Can we get you to tell us some more things? And he kept saying, can I have a lawyer? Can I have a lawyer? Can I have a lawyer? And eventually they just said, well, if you want to talk to us, we're willing to talk to you. And then they ended the interview. So unless the court has any further questions, the state would rely on its briefs and ask this court to affirm the trial court's judgment.
Thank you, counsel.
First, Judge Sutton, I'd like to answer your question as to what the detectives promised during the March interrogation. They do walk back the promises of no additional time a little bit. In March, what they say is about 9 minutes in, like you said, you're already doing 18 to 21 or whatever. Like we had said before, you're only going to get so much on top of that anyway. And then shortly after that, they threaten him with the death penalty, and then they say, you're looking at some time, but you're already doing the bulk of it. You're not gonna get more than that. So they walk it back just a little bit, and they're not as explicit promises in that March interview, but they sort of, it's still the same talking points. I also want to point out that the promises of no additional time do continue after it becomes clear that he is going to be charged with murder. They do tell him, you're already doing the time, you're already doing the same time, you're already doing murder time, you're already doing it. And so the message remains, you're not going to get any additional time.
Did the detectives testify as to the reason why they had said there's not going to be any additional time?
It's touched on in the hearing. I don't think that was a focus of the testimony, though. I'm also not 100% sure about the record, what they said there. I want to touch on the state's point about threatening legal action, whether a threat can be still a coercive threat, even if the thing that they're threatening is in fact legal. For them to take Porter out of the 2nd District is a useful comparison for that. In that case, the two threats that rendered a statement, and actually a subsequent statement the next day, inadmissible. There were two threats. One was threatening a body cavity search, and one was threatening to charge everything he could think of since she was wasting his time. And those threats, although she was in jail at the time, were coercive. In addition, just on the point of whether this case is distinguishable from Wilson, the line that the state would like to draw is between this and Wilson, is that this was not an intentional coercive tactic. The intent of the detectives actually does not matter, and that's well-established case law that their intent is not the deciding factor of whether something is coercive. But in addition, I do want to note that in Wilson, that wasn't the line. In Wilson, the issue was about whether an implicit promise was enough to be coercive or whether it needed to be explicit. And this court wouldn't even say that, this court said even an implied promise is enough. And now in this case, we are getting the explicit promises of immunity that everyone in Wilson agreed would absolutely render a statement coerced. And with that, if the court has no more questions.
Seeing none.
Thank
Counsel.
you.
Well,
Oh, sorry, I'm sorry, Counsel.
We're back.
It's like-
I lost my papers.
That's okay. You had mentioned that at about, I think you said 2 hours, 43 minute mark on that first go round, that it became clear
Yes.
that they were going to charge him.
Yes.
And you indicated that it was at that point that they said if he confessed, he would get the 18 years
Yes.
right on top of the sentence.
Mhm.
Was it after that point that he started talking?
Yes, it's actually in both February and in March. The detectives tell him, after they read him his Miranda rights, and then after they tell him, actually, we are going to charge you for this, they say, but wait and hear us out. And they talk to him about the consequences. They say that he would get life without parole if he didn't cooperate, and that he would get only 18 years if he did cooperate. And it is after that discussion where he is waiting for them to say their piece. It's after they tell him all of that he starts talking, both in February and in March.
Okay, but I just want to make sure I understand that it was, they did make it clear to him at some point, 2 hours, 43 minutes into it, that he was going to be charged.
Yes, yes. Eventually they make it very clear. They say, you are going to be charged with this, but before you say anything, hear us out. And then they go into they sort of pivot into the different leniency promises and threats. And then they continue with the interrogation as and he sort of paces them.
Thank you.
Thank you.
Thank you both for excellent oral presentations today. Court will take the matter under advisement. We will issue a decision which will be mailed to all parties as well as posted on the Ohio Supreme Court website.